Every case this channel has covered cites one decision. One case, decided June 26, 2008, District of Columbia versus Heller, 554 U.S. 570. The suppressor lawsuit, the AR-15 cert grant, the 18-year-old handgun ban, the Rahimi marijuana ruling, the DOJ lawsuits against Virginia and California, the Bruen test itself. Every single one of them rests on the constitutional foundation this case built. Without Heller, none of those cases exist in their current form. Without Heller, the Second Amendment is not an individual right. It is a collective one, available to the militia, unavailable to you. Here is the paradox. Heller is the most cited case in American gun law. It is also one of the most widely misunderstood, even among gun owners who care deeply about this area of the law. Most people know Heller established an individual right. Very few can accurately explain what the majority actually held, what Scalia's common use language requires as a legal standard, what the 6 categories of regulations the opinion explicitly preserved mean for every gun control fight going forward, or what 4 major constitutional questions the decision deliberately left unanswered, questions that became the entire landscape of Second Amendment litigation for the next 18 years and are still being litigated in federal courts today. This video closes that gap completely. Let me start with something most gun owners do not know about this case ijaroso, because it reframes the entire story from a lucky lawsuit into a deliberate constitutional strategy. District of Columbia versus Heller did not happen by accident. It was designed. Robert Levy, a constitutional attorney at the Cato Institute, built the case from scratch starting in 2002. Levy was not a gun owner himself. He was a constitutional lawyer who believed the Supreme Court needed to resolve the Second Amendment's individual right question, and that it needed the right case to do so. He assembled 6 plaintiffs carefully, a range of ages and even gender balance, 2 African-American residents, all living in high-crime areas of Washington, D.C., who had genuine, concrete self-defense needs. The case was originally filed in federal district court in 2003 as Parker versus District of Columbia. Only one plaintiff survived to reach the Supreme Court, Dick Heller, a licensed special police officer authorized to carry a handgun while on duty at the Federal Judicial Center, had applied for a registration certificate for a handgun he wished to keep at his home for self-defense. The District of Columbia denied his application. That denial was the concrete, particularized injury that gave him standing to sue. The other 5 plaintiffs had never applied for registration. They had not suffered a direct, traceable injury that a court could redress. They were dismissed. Heller remained, and the case took his name. Now let me tell you precisely what Heller was challenging, because the 3 D.C. laws at issue defined exactly what the Supreme Court had to answer. The first law, D.C.'s near-total ban on handgun registration. Under the Firearms Control Regulation Act of 1975, it was a crime to carry an unregistered firearm in the district. The registration of handguns was prohibited entirely, meaning there was no legal pathway through which a D.C. resident could register a handgun for home possession regardless of their circumstances. The second law, a requirement that all lawfully owned firearms kept in the home be kept unloaded and disassembled, or bound by a trigger lock or similar device. A lawfully owned rifle or shotgun could not be kept in a condition ready for immediate use. It had to be rendered inoperable. The third law, a prohibition on carrying an unlicensed firearm anywhere in the home. A provision that, combined with the registration ban, meant there was no legal way to possess a functional handgun in a D.C. home under any circumstances. The district court dismissed the case, holding that the Second Amendment protects only militia-related firearm rights. The D.C. Circuit reversed, finding the Second Amendment protects an individual right and that the D.C. laws violated it. The District of Columbia petitioned the Supreme Court. Cert granted. Oral argument held March 18, 2008. Decision issued June 26, 2008, 5-4. Justice Scalia wrote the majority, joined by Chief Justice Roberts and Justices Kennedy, Thomas, and Alito. 2 separate dissents. Justice Stevens joined by Souter, Ginsburg, and Breyer on one side. Justice Breyer joined by Stevens, Souter, and Ginsburg on the other. Now let me take you through what Scalia actually wrote, because the majority opinion is the most important document in the history of Second Amendment law, and your audience deserves to understand it at the level of precision it requires. Scalia began with the text. He divided the Second Amendment into two grammatical components: the prefatory clause, a well-regulated militia being necessary to the security of a free state, and the operative clause, the right of the people to keep and bear arms shall not be infringed. His core structural holding on the relationship between them. The prefatory clause announces a purpose. It does not limit the operative clause. A purpose clause cannot narrow a right the operative clause grants without qualification. The operative clause is where the right lies. The prefatory clause explains one reason the founders valued it, but does not confine it to that reason alone. On the people, Scalia held this refers to individuals, not a collective body or the militia specifically. The Bill of Rights uses the phrase "the people" 6 times across the First, Second, Fourth, Ninth, and 10th Amendments. Every other use refers to individual rights, not collective rights, not government-organized bodies, not militias. The Second Amendment uses the same phrase. It means the same thing on keep and bear arms. Keep means to have possession of. Bear means to carry. The phrase together encompasses individual possession for private purposes, not merely organized military service. Scalia traced both terms through founding-era dictionaries, legal commentaries, and state constitutional provisions, and concluded their plain meaning covered individual possession for self-defense. The core holding, stated as Scalia wrote it, the Second Amendment protects an individual right to possess a firearm, independent of service in a state militia, and to use that firearm for traditionally lawful purposes, with self-defense in the home being the central application of that right. D.C.'s handgun ban was unconstitutional because it banned an entire class of arms, handguns, that are overwhelmingly chosen by American society for self-defense. Scalia's language is worth quoting directly. A prohibition of an entire class of arms that is overwhelmingly chosen by American society for the lawful purpose of self-defense is constitutionally invalid. He connected that holding to the common use standard drawn from United States versus Miller, the court's 1939 Second Amendment precedent. The Second Amendment protects weapons in common use at the time for lawful purposes. The trigger lock requirement was independently unconstitutional because it made it impossible for citizens to use their legally owned firearms for the core lawful purpose of self-defense in the home. A right you cannot exercise at the moment you need it most is not a right. It is a formality. Now let me take you through the common use standard, because this is the language that controls every weapons case being litigated today, and it is far more ambiguous than most people realize. Scalia drew on Miller's formulation, weapons with a reasonable relationship to the preservation of a well-regulated militia, and reframed it as a common use test. The Second Amendment protects arms in common use at the time for lawful purposes. He connected this to the historical tradition of prohibiting dangerous and unusual weapons. The implication, if a weapon is in common use for lawful purposes, it is presumptively protected. If a weapon is dangerous and unusual, meaning not commonly owned and disproportionately dangerous, it may fall outside Second Amendment protection. Here is the critical problem Scalia left for every court that followed. He did not define what common use means quantitatively. How many units must be in circulation? How widespread must the use be? Does common use mean common among all Americans or common within the community of gun owners? And is the relevant moment the time of the founding, the time of the regulation, or the time of the legal challenge? He also did not define dangerous and unusual with any precision. He listed M16 rifles and similar weapons most useful in military service as potential candidates for the dangerous category, but did not establish a test for how courts should make that determination. These definitional gaps became 18 years of litigation. They are directly and actively at issue in Viramontes versus Cook County, where the Supreme Court granted certiorari on June 30th, 2026, to decide whether AR-15 platform rifles satisfy the common use standard or fall into the military weapons carve-out. Now I need to walk you through the 6 categories of regulations Scalia said Heller should not be read to cast doubt on, because these 6 categories are the constitutional landscape on which every major gun control fight since 2008 has been waged. Scalia listed them explicitly in the majority opinion. 1. Long-standing prohibitions on the possession of firearms by felons and the mentally ill. 2. Laws forbidding the carrying of firearms in sensitive places such as schools and government buildings. 3. Laws imposing conditions and qualifications on the commercial sale of arms. 4. Laws prohibiting dangerous and unusual weapons. 5. Laws prohibiting the carrying of concealed weapons. 6. Laws regulating firearm storage to prevent accidents. He added a critical footnote. This list does not purport to be exhaustive, meaning Heller is not an endorsement of any and all gun regulations not on the list, but it is also not a declaration that only regulations on the list are permissible. The list is illustrative. It represents the categories of long-standing, historically grounded regulations the court was not disturbing. Connect those categories to the litigation your audience already knows from this channel. The first category, felon and mental health prohibitions, is the direct constitutional foundation of 18 U.S.C. Section 922G, and the ongoing circuit split over whether nonviolent felons can challenge the ban as applied to them is a fight over how far that category extends under the Bruen historical tradition test. The third category, conditions and qualifications on commercial sale, is what the NFA's registration requirements rest on, and whether that category survives after Congress eliminated the transfer tax is the precise question pending in Silencer Shop Foundation versus ATF. The fourth category, dangerous and unusual weapons, is the government's primary argument for why assault weapons bans survive Heller, and it is the argument Viramontes will either validate or demolish. Now let me give you both dissents, fully and fairly, because your audience will encounter these arguments constantly in legislative debates and media coverage, and understanding them makes the Heller holding more defensible on its own terms. Justice Stevens, joined by Souter, Ginsburg, and Breyer, argued the Second Amendment protects the right to bear arms only in connection with service in a well-regulated militia, not for individual self-defense. Stevens's textual argument was careful. He said the prefatory clause is not merely a purpose statement, it is a limiting clause that defines the scope of the operative right. The founders, Stevens argued, knew how to write individual rights without reference to collective purposes. They did so throughout the Bill of Rights. When they chose to include the militia clause in the Second Amendment, they meant it to confine the right to militia service. The right exists, but it is a militia right. Stevens also argued that bear arms was a term of art at the time of the founding, meaning to serve in an organized military capacity. He cited early state constitutions that expressly mentioned individual self-defense as a separate justification for gun rights, arguing that the absence of self-defense language in the Second Amendment was deliberate. The founders could have written self-defense into the text. They did not. Stevens called the majority's reading strained and unpersuasive, and its conclusion overwrought and novel. He noted that dozens of lower court decisions interpreting the Second Amendment as a collective right would now need to be repudiated or rewritten. He was correct about that. They were. Justice Breyer, joined by the same 3 justices, wrote separately to address the standard of review. Even conceding for argument that the Second Amendment protects some individual right, Breyer argued courts should evaluate gun regulations using a flexible interest-balancing approach, weighing the magnitude of the individual's Second Amendment interest against the government's interest in public safety, asking whether the regulation is proportionate to the safety benefit it achieves. Scalia rejected this directly and with considerable force. The Second Amendment, he wrote, is itself the product of an interest balancing done by the people through the constitutional ratification process, elevating the right to self-defense above other interests. Judges cannot rebalance what the Constitution has already balanced. The right exists as the founders wrote it. It is not subject to judicial recalibration every time a legislature identifies a public safety problem. That rejection of interest balancing in Heller became the foundation for Bruen's elimination of means-end scrutiny 14 years later. Heller rejected it first. Bruen made the rejection permanent and universal. Now let me give you the 4 questions Heller deliberately left open, because these are not trivial loose ends. They are the 4 most contested constitutional questions in American firearms law, and every major Second Amendment case litigated since 2008 is a fight over one of them. The first open question, the carry question. Heller held the Second Amendment protects the right to keep a firearm in the home for self-defense. Scalia focused the opinion on the home, the place, he wrote, where the need for self-defense is most acute. He did not address whether the right extends to carrying firearms outside the home in public. That question was answered 14 years later in New York State Rifle and Pistol Association versus Bruen, 2022, which held the Second Amendment protects a right to carry in public for self-defense. The Wolford versus Lopez decision from June 25, 2026, covered in this channel's dedicated video, is a direct application of that Bruen ruling to Hawaii's affirmative permission requirement for businesses. The second open question, the standard of review. Scalia explicitly declined to name the standard of scrutiny the majority applied. He said only that D.C.'s handgun ban would fail under any of the standards of scrutiny the court typically applied, but he did not establish a specific test for future Second Amendment cases. That gap gave lower courts 14 years to fill with their own improvised balancing frameworks, producing the chaos of inconsistent results that eventually forced the Supreme Court to issue Bruen in 2022 and replace the lower court's frameworks with the text, history, and tradition test. Heller identified the problem. Bruen provided the solution. The third open question, the AR-15 and the dangerous and unusual category. Heller said the government can ban M16 rifles and weapons most useful in military service. It separately said the common use standard is the operative test for other weapons, but it defined neither phrase with precision. What counts as in common use? What makes a weapon dangerous and unusual? How similar to the M16 must a semi-automatic rifle be to fall within the military weapons carve-out? These are precisely the questions the Supreme Court will answer in Viramontes versus Cook County, cert granted June 30th, 2026. That case is Heller's most important unresolved legacy. It has been 18 years in the making. The answer is coming by June 2027. The fourth open question, incorporation against the states. Heller was a federal case. The District of Columbia is a federal district, not a state. The decision bound the federal government directly, but states were not parties to the case, and the decision did not address whether states could enact their own handgun bans and gun restrictions without Second Amendment constraint. That question was answered 2 years later in McDonald versus City of Chicago, 561 U.S. 742, 2010, where the Supreme Court held that the Second Amendment is incorporated against the states through the 14th Amendment. The individual right Heller recognized is not only a limitation on federal power, it limits every state legislature, every city council, every county government in the country. McDonald is what made every state gun law subject to Second Amendment challenge. Without it, Heller would have been a ruling about one federal district with no application to California, New York, Illinois, or any other state. Let me close with where Heller sits today, because this is not history. It is the live constitutional foundation under every Second Amendment argument being made in every courtroom in America right now. The Bruen test is built on Heller. The common use standard, the dangerous and unusual carve-out, the rejection of interest balancing, the individual right holding, all of it comes from Heller. Bruen did not replace Heller. It operationalized it. It gave courts the specific two-step test Heller declined to articulate, built around the historical tradition framework Heller gestured toward but never formalized. The felon in possession circuit split, covered in this channel's dedicated Section 922G video, is a fight over the scope of Heller's first presumptively lawful category. How far does the felon prohibition extend? Does it reach non-violent offenders with no history of danger? That is a Heller question being litigated under the Bruen test. The suppressor lawsuit, covered in this channel's first script, challenges NFA registration requirements. The government's defense relies partly on Heller's third presumptively lawful category, conditions and qualifications on the commercial sale of arms. Whether a prior approval registration requirement counts as a permissible condition on commercial sale, or whether it functions as an outright prohibition on the exercise of a right, is a Heller question. Viramontes versus Cook County is the most direct Heller question pending at the Supreme Court. Does the AR-15 satisfy Heller's common use standard or fall into Heller's military weapons carve-out? The entire case is a dispute about the meaning of two passages in Scalia's 2008 opinion. Heller was decided 5-4. The four justices who dissented, Stevens, Souter, Ginsburg, and Breyer, are gone. They have been replaced by justices who have consistently applied and extended Heller's individual right holding. The decision is not going anywhere. It is not going to be reconsidered. It is not going to be reversed. It is the constitutional floor beneath every Second Amendment case being litigated in America today, and it will remain so for the foreseeable future. Understanding Heller is not optional for anyone who wants to follow this area of the law. It is the beginning of every analysis. It is the case every other case refers back to. It is the reason this channel exists. Because in June 2008, 5 justices of the Supreme Court of the United States looked at the Second Amendment's text and held that it means what it says.